guilty plea on your client's behalf. Is this the? Oh, it's a capious, but it's a misdemeanor, right?
Yeah. Right.
Okay. All right. Court
Your Honor, I don't
a
think
not
she's
guilty.
been arraigned, actually.
I concur, Judge.
Got it. A capious in the file from 05, February 22 of 05.
Well, you have the court file, so that is what controls.
Okay. Yeah. Anyhow, I mean, I'm just give me your bond arguments.
Either way, Your Honor, it's not assaultive and it's from 03, so no objection to a personal.
No objection, Judge.
Thank you. All right. Order set bond of 1,000 personal. And next court date will be pre-trial July 9th in front of Judge Jones here in this building. And if you have a seat, we'll get you some paperwork. Okay, DDC, we're back to you.
Devontae Rayshawn Barber.
Thank you, sir. So we're going to start with some tickets you got where you missed some court dates. When you miss those dates, the judge issued an arrest warrant for you. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and if you cannot afford for you, do you understand those rights? All right, first ticket is P 1675591 with a charge of trespassing. The other ticket is P 1690650, charge of brandishing a facsimile firearm. These are misdemeanor charges. Maximum penalty you face on each is up to 93 days in jail and or a $500 fine. I'm going to set aside the arrest warrant, enter a not guilty plea on your behalf, give you a personal bond. Your next court date is a pre-trial July 14 in front of Judge Yancey here in 36th District Court. Your other matter today is 25058426, State of Michigan versus Devontae Rayshawn Barber, counsel.
Well, hearing on behalf of the people.
Judge Miguel Rico, here on behalf of Mr. Barber, does recognize any violation of constitutional rights. Waive the complaint stands due to request at this point. Not guilty, that.
Court will enter not guilty plea on your client's behalf as to bond, please.
Honor, this is the 15-year felony of manslaughter. Here is where the victim, who is a 44-year-old man, and the defendant get in an argument, which then turns physical. As the defendant turns to leave, he then turns back and hits the complainant in the face. The complainant then falls and hits his head on the ground. He is arrested, not at his home, but I believe it might be his girlfriend's home. This is all captured on video. There were also witnesses at the scene that pretty much say the same. After the defendant had hit the complainant, he said, "I told you to shut up talking to me." And I also noted in the IR, he returned the gas station and saw the complainant not moving, but he did nothing to aid the complainant in order to render any type of aid because he was still laying on the ground. The police took a statement after arrest. The allegations are that he first denied it being at the gas station overall. And then he said later he was there to buy cigarettes, Your Honor. So there comes a potential flight risk here. This is more often looked at as a misdemeanor manslaughter type of thing, but Here is where he actually walked away, turned and rethought, and then struck him right in the face. So it's kind of a sucker punch. I do note he has an assaultive background. He had a 2018 UDAA with a count of felonious assault, a 2018 home invasion third, and a 2021 assault and battery. And for those reasons, Your Honor, people believe he is a danger to the community and a potential flight risk. I'm asking for 150,000 cash surety as well as a tether in this matter. Thank you.
Thank you.
On behalf of Mr. Barber, and I'm not downplaying or negating any seriousnesses of the charges alleged against him. Just like to say for the record, in the very current moment, he is presumed innocent until proven guilty beyond a reasonable doubt. Judge, my client's very young; he's 26 years old. This is arguably a case where an assault and battery could have just spurred out of control in terms of something that it should never been. My client and the incident report and the admissions he made himself does pay some credence to the fact that there is some defensible claims for my client to pursue at a later date that we're not going to discuss today, but there are those avenues for him, and it is in the incident report. Judge, I would be asking you for some type of reasonable amount of bond here. And when I say reasonable, I mean take into consideration the flight risk aspect and the dangerousness to the community. I don't find my client to be a particular danger to the community, especially if we take what he's discussed with us in interview and what's mentioned in the incident report as fact. It appears that there was some aggression on the other side here. Of course, we're only hearing the one side of it today. Judge, I would ask you today to entertain an amount of bond that is reasonable, and to entertain perhaps home confinement for Mr. Barber to be able to exit without detention in that situation. He does have many physical mental issues that he's discussed with us, some of which being bipolar, depression, schizophrenia. He did provide us an address in which he lives in the city with his brother and sister. He's a lifelong resident of the city of Detroit, or of the state of Michigan, I'm sorry, Judge. And I would be at discretion, but would be asking this court to entertain a reasonable amount of bond so that we may work from there, Judge. Thank you.
Thank you. If you don't mind, can you direct me to the point of the report that you say is
Yes, Judge. So if we look under the admissions and concessions subheading, and we work down 9 lines from the bottom, Judge. I'll start off by saying Javante stated he got aggressive and told the victim to stop talking to him like that. And at the time, the victim asked Javante, "What are you going to do?" and then got in his face. Javante told the victim, "Get out of my face before I agree." Javante stated he was arguing with the victim, and the victim was saying he was going to do something. So Javante took it as a threat. Javante stated he was face to face with the victim and then walked away. Victim kept speaking to him, and that's when the altercation began. So there were some presumably fighting words exchanged.
I mean, it goes on to say that the defendant walked away and then turned around and hit the victim. It's unfortunate that, at least from what's alleged, he didn't just walk away and keep walking, but here we are. All right. Court does find the defendant poses a threat to public at large. There's some indication in the report that we've seen the deceased many times in the past, that they hadn't had any issues in the past. Don't know what would have happened this time, but allegations are very significant. For those reasons, there will be, if you're able to post bond, a GPS tether on house arrest, and bond will be set at $100,000 cash or surety. That, sir, will give you a bond redetermination hearing on Wednesday, July 2nd, in front of Chief Judge McConaughey. And further dates are probable cause conference on July the 10th, and preliminary exam July 17, both in front of Judge Jakay here in 36th District Court. Thank you, sir. You can step aside.
My name is Michael Cooper.
Thank you. And this is 25-058-429, State of Michigan versus Michael Roosevelt Cooper, counsel.
The Coyle appearing on behalf of the people.
Judge Miguel Rico, appearing on behalf of Mr. Cooper, my client's advised of his constitutional rights. The wage form written complaint stands mute. He requested this court enter a not guilty plea on his behalf as to all counts.
Court will enter a not guilty plea on your client's behalf as to bond.
Your Honor, the people are requesting a 10,000 personal bond. The felon in possession charges preface on the arson, 4th degree. He's not doing anything assaultive with it. They see the outline of a pistol, and he did give a false name, but no objection to 10,000 personal, Your Honor.
No objection, Judge.
Thank you. Mr. Cooper, while this case is pending, you are not to possess a gun at any time. Is that clear, sir?
Sir.
Court will set bond at $10,000 personal. Next court date is July 10, probable cause conference. July 16, preliminary exam, both in front of Judge Jefferson here in 36th District Court. Thank you, sir. You can step aside.
Thank you. Right here, brother. Shut the flag line. Thank you. Camera, see you forward back. David, referee.
Thank you. One moment. All right, Mr. DeGraff and Reed, you've got quite a few tickets where you missed court dates. When you missed those dates, a judge issued an arrest warrant for you. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and if you cannot afford an attorney, the court will provide one for you. Do you understand those rights, sir? All right, first ticket is P 1392811 with charges of improper plates and driving while license suspended. Ticket P 1020736, driving while license suspended, no insurance misdemeanor. P 1150215, improper plates, driving while license not valid, driving unregistered vehicle. P 998683, driving while license not valid. 184390501 and 02, driving while license suspended, no insurance misdemeanor. P 1425270, driving while license not valid, driving unregistered vehicle, no insurance misdemeanor. P 1564646, driving unregistered vehicle, improper plates, driving while license not valid. P 1578015, no insurance misdemeanor. And P 1578739, improper plates, driving unregistered vehicle, driving while license suspended. Sir, these are all misdemeanor charges. Maximum penalty you face on each is up to 93 days in jail and or a $500 fine. I'm going to set aside the arrest warrants. Enter a not guilty plea on your behalf, give you a personal bond. Your next court date is a pretrial July 14 in front of Judge Sherman here in 36th District Court. Your other matter today is 25-058-432, State of Michigan versus David Terry DeGraff and Reed Jr. Counsel.
Thank you, Magistrate. Steve Benson, P 71917.
Judge Miguel Rico, on behalf of Mr. DeGraff and Reed, my client's been advised of his constitutional rights. He waives the form reading the complaint. Stands mute. You requested this court enter a not guilty plea on his behalf as to all counts.
Court will enter a not guilty plea on your client's behalf as to bond.
Magistrate, I'm not going to be objecting to a personal here. I am going to be asking for monitorization, though. I know you see that he's had 4th offense notice, but that only covers a small portion of his prior convictions. He's been doing this for 40 plus years. I mean, going back to 1983, I have the same type of charge, a felony RCSP. 84, same thing, felony receiving, concealing, stolen property. 86, larceny motor vehicle. 88, controlled substance felony. 88, he escaped from prison, was charged with it, convicted of it. 91, felony larceny motor vehicle. And then we have the home invasions in 02 and 07. In between that, I have 97 A and B. After the most recent felony home invasion, I have a 2012 domestic violence conviction. And now we have this defendant, I think he's 60 plus years old, 40 years after his first felony conviction, and he's backing up his truck and stealing items from a premises. We think the likelihood of conviction is high here because the police ended up catching him. on the premises. So we do feel as though there's a level of danger the defendant poses when he serves significant jail and prison time for offenses just like this, and he continues to do it. So again, the personal bond is fine, but we are asking for monitorization here.
Thank you.
Judge, no objection to a personal bond. In terms of monitorization, I leave it as for his discretion. My client is 61 years old. He has resided in Michigan his entire life. He's provided my office with a good phone number, a good address in which he goes with his mother. He does have 3 children. And I do know, Judge, the practical history. I don't have as much information as the people do sometimes. I just get rehab notices, which indicates to me that 2007 was the last time that he was convicted of an offense, or at least a felony offense. I would be leaving the monitorization in your discretion, Judge. If you were to impose monitorization, I would ask that you have DDC mark my client as medical, because I presume you'll remain in DDC for a few days working on that other situation.
Thank you. DDC, can you mark his file medical, please? Counsel, you indicated he's got, I think, 3 children. Are these children or are they grown adults at this point?
Judge, I'm sorry, he has 4 children and 1 is a minor child.
Thank you. You say he lives in his mother's home?
Yeah.
Okay, where's that minor child live?
My office did not ask. I can ask.
Go ahead.
Mr. DeGraffenreid, where does your minor child live? Repeat it one more time, but loud and clear. Okay, so I his child lives with the mother.
Okay. All right. Someone puts you on a GPS tether, you'll be on house arrest on that tether. You leave your house, you're gonna wind up right where you are right now, understand? Court was set bond at $10,000 personal. Next court date is July 10, probable cause conference, July 17, preliminary exam, both in front of Judge Jefferson here in 36th District Court. Thank you, sir. You can step aside.
Thank you.
Step on the black line, bro. So you hold it.
What's your name, sir?
Right, the white brother.
Is this number 5? I mean, number
Number 8.
8? Okay. Oh, he's got a lot of aliases. All right, sir, we're gonna start with some tickets you got, and you missed some court dates on those tickets. When you miss those dates, a judge issued an arrest warrant for you. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and if you cannot afford an attorney, the court will provide one for you. Do you understand those rights, sir? All right, first ticket is P1082662 with charges of failure to display valid license, no insurance misdemeanor, driving unregistered vehicle. The other ticket is 512438 with charge of no operator's license on person. These are all misdemeanor charges. Maximum penalty you face on each is up to 93 days in jail and or $500 fine. I'm going to set aside the arrest warrants, enter a not guilty plea on your behalf, give you a personal bond. Your next court date is a pretrial, July 14, in front of Judge King here in 36th District Court. Your other matter today is 25-05-8435, State of Michigan versus Brandon Xavier White, Ratliff Counsel.
Thank you, Magistrate. Good afternoon. Steve Vincent, P71917.
No, brief on behalf of Mr. White Ratliff. Judge McClatchy advises constitutional rights, waives forming the complaint, stands due, and you requested this one to be not guilty pleas we have as to all counts.
Court will enter not guilty plea on your client's behalf as to bond.
Magistrate, it's available, so I'm asking for it. We're going to be asking for a remand under 6.106B1, lowercase a, lowercase double I, uppercase a. This defendant right now in that that statute and its subsections basically state, magistrate, that that you can deny bond if this defendant is on probation, parole, or bond for a violent felony while he was in the commission of whatever it is he's being charged with right now, with that being a violent felony as well. You can see he's being charged with the DV third as well as the FA. Now, magistrate, the reason why he's on bond right now, not parole, I'm sorry, on probation. My apologies. He's on probation because he got already a domestic violent third offense conviction. He was convicted of the DV third, and this was an assault of a pregnant individual, August 23rd of 23. He's on 3 years probation. So while he's on probation for a DV third conviction, here being charged with a DV third as well as an FA, he allegedly ended up assaulting this individual that just wanted to break up with him. And apparently he ends up using his head to try to open the door. That didn't work. And then once the door was opened, he allegedly hits this individual with a rock and then subsequently shatters her front windows, only to leave the premises, and the police apparently find him, but then he flees, but then he's ultimately caught. Now, magistrate, I have a July of 2015 DV conviction, and August 31 of 16 DV second conviction, assault of a pregnant person, a February 2020 reckless driving, a 2020 felony R&O, and then that most recent conviction. Respectfully, we find him to be a danger. He's on probation for an assaultive crime. These are assaultive allegations. Remand's available. We're asking for it.
Thank you.
Judge, on behalf of Mr. White Radcliffe, I do understand why remand is available and why it is a may, not a must or shall. I ask you to consider that part of it and consider a different alternative rather than remand in this matter. I'm reasonable, Judge. I don't come up here and request crystal balls, and I don't think that it would suffice. So I'm going to make my argument. I'm going to ask you to fit a condition on Mr. White Radcliffe that would serve both your objectives. I think home confinement would do that, Judge. And I would be asking for that, actually. I'm going to give you a little bit of information on my client. He's a lifelong resident of Michigan. He has 3 children, all minor children, one of them being an 11-month-old, the oldest being 8 years old, Judge. He indicates in my office he's the sole provider for these children. I do understand the priors that he's going on. I do understand the probation that he's on right now. I have no notice or understanding of a violation at this point that he's received, but I'm sure it'll come in due time. Judge, I understand everything, all the allegations. He doesn't need any contact with this complaining witness. They reside at separate addresses. He's provided me address different than complaining witnesses. I think a no contact order, a home confinement order, and any other conditions you deem necessary would suffice rather than a remand. I mean, there are very serious allegations, but I believe the remand would serve for the most serious of those offenses. And quite oftentimes we've had offenses like these receive some type of monetary bond, if not receiving a personal with other conditions. So I will leave it at your discretion in regards to that, Judge. That's my argument.
Thank you. Yeah, I mean, these are disturbing allegations. I mean, start with the history of violent convictions. He's already got a DV third felony conviction out of Wayne County. Wouldn't even want to speculate on how many cases were filed and then dismissed while he was racking up those 3. And now here we got a 4th, plus some additional convictions, which give this court a lot of concern. And the allegation here that he's hitting the complaining witness in the head with a rock. I don't know, sir. Put your hand down, sir. I'm sure you're not going to say anything helpful to yourself. Somehow I got to get through to you that you can't beat up your girlfriends. I don't know what I have to do to accomplish that, but it's not acceptable. It's not acceptable socially. It's not acceptable legally. So here's the conditions of bond. You're not to possess a firearm or any other dangerous weapon. You're to have no contact with Ms. Parks. Have no contact with the Clements address. Should you post bond, you'll be on GPS tether on house arrest. You understand those conditions of bond, sir?
Yes, sir. Yes, Your Honor.
Court will set bond in this matter $200,000 cash or surety. I'll give you a bond redetermination hearing on Tuesday, July the 2nd, in front of Chief Judge McConico. Further dates will be probable cause conference, July 9, preliminary exam, July 16, both of those in front of Judge Takei. Thank you, sir. You can step aside.
Yes, Your Honor. I have one question, please, if I may. May I ask a question, Your Honor?
Yes, go ahead.
We are all innocent until proved guilty, and I know it says I beat that woman up. There's a physical appearance that we all have. The woman hair was just done. I just got her hair done.
Mr. White Radcliffe, I'm sorry to cut you off. This is your attorney, Miguel Rico speaking. I understand what you're trying to tell the court. It's not the time for it. The judge here has ruled on your bond conditions. You're gonna have another hearing on July 2nd with another judge where we can try to get that amount lowered. I would advise you, you have the right to speak. I would advise you so hard not to speak about the case at all, especially with the prosecutor on the screen with you. There's no reason for that. You should only be speaking to your attorney about these facts and nobody else, nobody on the jail phone, nobody in the okay? Only your attorney, please. If you want to speak, I'll stop and you can continue, but that's my advice to you.
All right, you've heard what your lawyer had to say. You want to keep going or you want to take his advice, which I would suggest you do.
Yes, Your Honor.
All right, you're all set. You can step aside. What's your name, sir? Thank you, Mr. King. Mr. King, we're gonna start with a traffic ticket where you missed the court date. When you missed that date, the judge issued an arrest warrant for you. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and if you cannot afford an attorney, the court will provide one for you. Do you understand those rights?
Yes, sir.
All right, this ticket is P1697502 with a charge of driving without cycle endorsement. And it's a misdemeanor charge. Maximum penalty you face is up to 93 days in jail and or $500 fine. I want to set aside the arrest warrant, give you a personal bond, and enter a not guilty plea on your behalf. Your next date is a pretrial, July 15, in front of Judge Kennedy here in 36th District Court. Your other matter today is 25-05-8434, State of Michigan versus Oliver Douglas King II. Counsels.
Mr. Coyle appearing on behalf of the people.
Judge Miguel Rico, appearing on behalf of Mr. King II. My client advises constitutional rights, waives forming the complaint, stands view, and you respectfully request that this court enter a not guilty plea on this behalf.
Court will enter a not guilty plea on your client's behalf as to bond.
Your Honor, Mr. King is currently on probation at Judge Edwards for a CCW. He was just placed on probation in December of last year. This is captured on video, him dragging a lawnmower and a trash can down the street from the complainant's residence. I don't know if it's his residence or a remodel, but on Elsa Street. And Mr. King makes admissions to taking those things, believing that nobody lived there. So for those reasons, Your Honor, he is on probation. He will be monitored. I'm asking for no contact with Mr. Johnson, the Elsa Street address, no objection to a $25,000 personal bond in this matter, and I am requesting a tether.
Thank you.
Judge, I have no objection to either of those.
So, is there your client? Does he have housing?
Obviously, yeah, Judge, he's provided us accurate housing. He's given us an address at least in which he lives alone. He does have children in the city as well. He's lived in Michigan for 4 years. To the tether requirement, my objection, I don't have an objection because I believe if he's on this, probation with the CCW, it might occur anyways. If this board's not inclined to a tether requirement, I'd be grateful for a personal bond about it. If he were to be tethered, I would have an address for him.
Is he working, to your knowledge?
No, he states that he's in trucking school.
How often does that school meet?
We can ask, Judge, I can ask.
Yeah.
Mr. King II, when you go to the trucking school, that meets in person?
I already completed my school. I failed my pre-exam because of my pre-trip exam, so I'm waiting on a new test date. That's all. So I just have to do some, like, freshen up. So I might go maybe 3-4 days, and then I can get a new test date, coast to coast trucking school.
Okay, so you don't need to be, the reason I believe the judge is asking is he might impose a curfew. You don't need to be out the house at certain times for school right now then.
If I did, it would be from like 8 to 3. I would be back.
It's 8 a.m. to 3 p.m.
Yeah, that's the hours of school.
Okay, thank you, sir.
All right. All right, here's what we'll do. While this case is pending, you're to have no contact with that Elsa Street address. You will be on a GPS tether. Curfew on that tether is 10 p.m. to 6 a.m. Ms. Coyle, am I recalling right? Are you okay with the personal?
Fine with personal.
All right. Court will set bond at 10,000 personal. Next court date, July 10, probable cause conference, July 15, preliminary exam, both in front of Judge Giles here in 36th District Court. Thank you, sir. You can step aside.
Come on. Got a headphone? But- the camera, the phone back.
What's your name, sir? Really loud.
Name is Orlando Deshaun Dalton.
Thank you. This will be case 25-058198, State of Michigan versus Orlando Deshaun Dalton, counsels.
Thank you. Steve Vincent for the people.
Judge Miguel Rico, on behalf of Mr. Dalton, my client's here to advise his constitutional rights, waive forming the complaint, and you request that this record not guilty of this game.
Court will enter not guilty plea on your client's behalf as to bond.
Magistrate, we don't see this every day, but this is a reissue on a CCW. I have an offense date, July 4th of 24. He was arraigned July 7th of 24. He was given a $5,000 personal, and then the officer didn't show up a couple of months later at the exam. So the people ended up refiling it. The lien was entered in, I think, the 17th of this month. We would just be asking for the same bond or whatever you feel is appropriate.
Thank you.
I have no objection. I would request a personal bond, Judge.
Thank you. Mr. Dalton, while this case is pending, you are not to possess a gun at any time. Is that clear, sir? All right, court will set bond at $2,000 personal. Next court date is probable cause conference. Madam Clerk. Questions? Should this be 7/18 or 7/8?
7/8.
And is it a Robbins case? This is just a CCW. Okay, and on the map, it actually does say 7/18. So. Okay, I'll let you do that. All right, next court date will be July 8th for a probable cause conference in front of Judge Robbins, and July 15 preliminary exam in front of Judge Giles, both here in 36th District Court. Thank you, sir. You can step aside.
Hey, Chris. Hey, Chris. The black line.
Defense counsel just chimed in.
See your phone back.
Christopher Trail.
Thank you, sir. What defense counsel just chimed in? Going once, going twice.
Hi, Your Honor. This is Attorney Evelyn Galvan. Mr. Brico will be in person doing the arraignments.
Oh, yep, I'm here, Ms. Galvan. Thank you.
Yeah, he's here. All right.
You can take it back out.
All right. This will be case 25-058-436. State of Michigan versus Christopher Trejo, counsels.
Lisa Coyle appearing on behalf of the people.
Judge Miguel Brico, appearing on behalf of Mr. Trejo. Judge, my client's been advised of his constitutional rights to waive the formal complaint. He stands mute. He requests that this court enter a not guilty plea on his behalf.
Court will enter a not guilty plea on your client's behalf. Ask the bond.
Your Honor, in this matter, I see Mr. Trejo is 22 years old, no criminal history that I am aware of. He did run from the officers after a crash and he had no insurance on his car. So I would be asking for no objection to a $10,000 personal and also no driving unless he has a valid driver's license in this matter. Thank you.
Thank you.
Thank you, Judge. I have no objection to either of the people's recommendations.
Okay, Ms. Coyle, did you say the car was uninsured or did he not have a license or both?
The car was uninsured. The car was registered to him. And I'm asking, based on the fact that he ran from the crash, it doesn't make a lot of sense, other than the fact that his car has no insurance, but I didn't see on the lien whether he had a valid license or not. But when your car is registered to you, it's not really hard to track who they're running to. So I think based on his age, being only 22, he doesn't have a criminal history. I'm just asking for that condition to make sure that if he does not have a driver's license that's valid, that he does in this case, moving forward.
Bro.
All right, sir, while this case is pending, you're not to drive a motor vehicle unless you have all the necessary documents, specifically a valid license and valid insurance on the vehicle, as well as current registration. Is that clear? Is that clear to you, sir?
Can you repeat that? My bad.
While this case is pending, you're not to drive a motor vehicle without all the proper documentation, specifically a license, valid insurance, and valid registration. Is that clear?
All right, that's clear.
Court will set bond at $10,000 personal. Next court date is July 10, probable cause conference, July 16, preliminary exam, both in front of Judge Taylor here in 36th District Court. Thank you, sir. You can step aside.
On the day of the car. Step on the black line. Face the camera. Say your full name, bro.
Norman Davis.
Thank you, sir. One moment. All right, Mr. Davis, we're going to start with some tickets where you missed some court dates. When you miss those dates, a judge issued an arrest warrant for you. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and if you cannot afford an attorney, the court will provide one for you. Do you understand those rights?
Yes.
All right, first ticket is P1152316. With a charge of parking autos on city property, and then P1562450, driving while license suspended. Sir, these are both misdemeanor charges. Maximum penalty you face on each is up to 93 days in jail and or $500 fine. I'm going to set aside the arrest warrants, enter not guilty plea on your behalf, give you a personal bond. Your next court date is a pretrial July 14th in front of Judge Sherman here in 36th District Court. Your other matter today is 25-058-437, State of Michigan versus Norman Javon Davis. Counsel.
Steve Benson for the people.
Miguel Rico on behalf of Mr. Davis. Judge, my client advises constitutional rights. He waives before the complaint and stands to request that this court enter a not guilty plea on his behalf.
Court will enter not guilty plea on your client's behalf as to bond.
Magistrate, serious but not assaultive. At this time, we're not going to be objecting to a personal, no guns through the pendency of the case.
Objection, Judge.
Sir, while this case is pending, you are not to possess a firearm at any time. Is that clear to you?
Sir.
Court will set bond at $2,000 personal. Next court date is July 7th, probable cause conference in front of Judge Robbins. July 14th, preliminary exam in front of Judge Giles, both here in 36th District Court. Thank you, sir. You can step aside.
I got a person. Black land. That's hard. Damn. Brian Woodville, Chair.
Thank you. This will be case 25-058-430, State of Michigan versus Deron Wendell Tarrant, counsel.
Thank you. Steve Vincent for the people.
Judge Miguel Rico on behalf of Mr. Tarrant. Judge, my client advises constitutional rights. Waives before the complaint stands mute. Request that this court enter a not guilty plea on his behalf.
Court will enter not guilty plea on your client's behalf as to bond.
Magistrate, I was torn on this one, but the people are going to err on the side of caution. On top of the allegations, this defendant just went through a gun case earlier this year, albeit it was dismissed, but only because the police officer didn't show up at the examination. And that happened in February here in 36D. And now we have about 4 months later, a neighbor dispute where this defendant allegedly pulls out a shotgun that was already propped, by his house, and then threatens the neighbor after pointing it at him. And then apparently, things got really heavy. The neighbor tried to get the gun away from this defendant, allegedly, and this defendant used the firearm as a weapon and hit the neighbor. And the gun was recovered. So, but they're neighbors, magistrate. They're neighbors. So we're gonna ask for.
It looks like a two-family flat.
Yeah. So we're gonna ask for cash here. We think this defendant does pose a danger with the case that was dismissed, and now with this case, knowing that he shouldn't have guns in the first place, and apparently the police upon that search warrant found ammunition as well. We're asking for a $10,000 cash surety, the way it's being charged in the allegations, and then a no contact whatsoever, possibly not even going back to that residence through the pendency of the case.
Counsel, and does your client have anywhere else to live?
Judge, I'll need to ask him that. That's a good question. I know you made reference to it looks like a family flat. Is it because the housing number is indicated?
Yeah.
Okay. I'll ask him that, Judge. Mr. Tarrant, do you have an alternative address other than the Stovall address for the time being?
Oh, sorry, I'm crippled. I don't have no other way to go. I'm crippled.
Okay, sir. Thank you. That was for the record, Judge, what he stated. I would ask for a personal bond, Judge. I really would. I know that the allegations themselves are ones that give this court some concern. I understand that Mr. Vincent states a case that got dismissed in the past. As far as I'm aware, my client has no convictions in criminal history. So he has no criminal history as far as convictions go, meaning that he's not on probation for the moment. He does indicate to us that he does take medicine at the house. He has an open wound on his leg that is infected. He does not work or has not indicated to us that he currently has a job, Judge. He does have a GED. Does have 2 adult children, lives at that address with his fiance. These complaint witnesses are the neighbor's kids, as was indicated in my office. So I would be asking for a personal bond. I understand why you asked if there's an alternative address, and we've heard Mr. Terrence say that he does not.
So he's got 2 adult kids
Yes, he does.
that he can't live with?
And Mr. Chairman, the reason we ask about a different address is because this court may be considering allowing you to leave without making you put up some money, but is probably concerned with you going back to that address for the time being. So if you're able to stay with one of your adult children or somebody else in the meantime, that would maybe give this court a reason to allow you to leave without posting a significant amount of bond. So that.
True, just
Go ahead.
I got a mom and a sister. I might can stay.
And they live locally?
Yes, sir. They live locally.
When you say you might be able to stay with them, is there any reason you know of that you wouldn't be able to?
Not really, no, sir.
All right.
I don't have any money. I'm crippled, man. I'm just trying to go home. I'm not lying.
All right, sir. While this case is pending, you are not to possess a firearm of any type while this case is pending. You're to have no contact with any of the complaining witnesses who live in the other flat. You're to have no contact with your flat. I will indicate that you can go there one time with a police escort to obtain any belongings you may need. But other than that, stay away from that Stokel address. Is that clear?
Sir, yes, sir.
Court will set bond at $25,000 personal. That means you don't have to pay anything today, sir, but if you breach any of those conditions of bond, you're gonna be standing right where you are right now, understand? All right, next court date is probable cause conference, July 10, preliminary exam, July 17, both in front of Judge Taylor here in 36th District Court. Thank you, sir. You can step aside.
Judge, may I briefly?
Mhm.
I understand you stated that he may not return to that address. He indicated he has medication at that address. Can you do it one time at school?
I did say he'd get a one-time escort. Okay. Mhm. All right, DDC, that's all the meals, right?
Yes, sir.
All right, we'll see on the female side. Good afternoon. What's your name, please?
How you doing today, Your Honor? My name is Reggie Whitaker.
Thank you. And it's going to be 25-05-8431, State of Michigan versus Bridget Renee Whitaker, counsel.
Coyle appearing on behalf of the people.
Judge Miguel Rico appearing on behalf of Ms. Whitaker. My client's been advised of her constitutional rights. She waived formally the complaint. She stands mute. She requests that this court enter a not guilty on her behalf as to all counts.
Court will enter not guilty plea on your client's behalf as to bond.
A strange case. The complainant and Ms. Whitaker have been friends for over 12 years. The only thing I see on Ms. Whitaker's record is a 2022 assault and battery. She allegedly had the complainant's registered gun in her purse, and she admitted that she took her friend's gun because she owed her some money from COVID that time. So for that reason, no objection to a personal, and of course, no weapons, Your Honor.
Thank you.
No objection from the defense side of those conditions.
Okay, Ms. Whitaker, while this case is pending, you're not to possess a firearm at any time. Is that clear?
Yes, sir.
Additionally, you're to have no assaultive contact with Ms. Allen. And court will set bond at $10,000 personal. Next court date is July 10, probable cause conference, July 15, preliminary exam, both in front of Judge Giles here in 36th District Court. Thank you. You can step aside.
Have a nice day, Your Honor.
Okay, you too.
Come on, Ms. McMillan.
Hi, what's your name, please?
Tiffany McMillan.
Thank you. This is case 25-045-563, State of Michigan versus Tiffany Joy McMillan, counsel.
Thanks. Steve Benson for the people.
Judge Miguel Brico, on behalf of Ms. McMillan, my client's been advised of constitutional rights. When she's standing here, she requested this court to deny guilty to yes.
Will enter not guilty plea on your client's behalf as to bond.
It's another neighbor dispute, magistrate. We allegedly have a defendant who is intoxicated. We have another individual involved, a neighbor. The other person didn't like apparently the defendant's kids on her front yard. And then these two women get into it. Now, interestingly enough, and I'm sure Mr. Brico will bring this up to you, it appears as though in the investigator's report, the complainant was the initiator, at least in terms of the physical altercation. Albeit this defendant ended up having to get a medical clearance because she was so intoxicated. So at this time, magistrate, we're not going to be objecting to a personal bond. I don't have priors regarding this individual. I'm going to let you handle the whole no contact thing. We would be asking for a no contact, but it appears as though they're pretty close in proximity.
Thank you.
Judge, I have no objection to personal bond and no objection to no contact. And as Mr. Vincent stated, yeah, my client indicated to us in our interview that she was struck or she's the one that called the police and there's a reach camera. And I guess it's all stuff that's been taken care of later down the line with this issue. When it comes to the no contact, we fashioned them before with neighbors. Then I would ask you to concoct something along those lines as well that would satisfy this court.
One's at 735 and the other is at 791. So they're not next door neighbors, correct? Kind of down the block. Both of you agree with me on that?
Yeah, it sounds good to me, magistrate.
All right, ma'am, while this case is pending, you're not to consume alcohol at any time. You're to have no contact with Ms. Sanford whatsoever. Court will set bond on this matter of $5,000 personal. Next court date is a pretrial July 9th in front of Judge Bryant here in 36th District Court. Thank you. You can step aside.
Thank you. We don't know your
Hey,
name.
DDC, that's everybody, right?
Yes, hold on.
All right.
Have a good evening, everyone.
You too.
Okay, have a good night.
All right. See everybody. Okay.
Thank you,
All
GDC.
right. Take care.